Good morning. My name is Kelly Bowl, and on behalf of the Michigan Negotiators Association, I would like to welcome you to today's learning opportunity, Merit Pay, Getting Creative with Salary Schedules. I also have the pleasure of introducing today's speakers, Adam Walker and Kevin Sutton. Adam is an associate in Miller Johnson's education practice and is a graduate of Central Michigan University and the University of Michigan Law School. I think maybe this is a good time for this Spartan fan to congratulate Michigan's men's basketball team for advancing to the Sweet 16 last night. In addition to general school law, Adam's practice is focused on labor and employment. Kevin Sutton, the office managing member of the Miller Johnson's Detroit office, is a graduate of Michigan State University and the Case Western Reserve University School of Law. Mr. Sutton often presents on topics relevant to his school clients, including transgender student rights, Title IX, social media in schools, student staff investigation, student privacy rights, and student staff discipline. Mr. Sutton also serves as the adjunct professor at Oakland University, teaching education law to students pursuing an ed specialist degree. And I will now turn it over to Mr. Walker and Mr. Sutton.
Well, thank you, Kelly, and good morning, everybody. This is Kevin Sutton, and Kelly's a bigger person than me because she did congratulate the Michigan men's basketball team. I'm having a hard time with not only my Spartans but the Big Ten this year. But I suppose we should be happy that Michigan, as the representative of the Big Ten, has advanced to the Sweet 16, and hopefully not all of us relied on those Big Ten teams in our brackets because. It's been ugly. It's been ugly. I hope everybody is doing well. Had a chance to enjoy a little bit of the sunshine and warm weather here the last couple of days. I want to thank the Michigan Negotiators Association for giving us the opportunity to put this webinar on and chat with you this morning. M&A, for those of you that have been involved for a long time, know such a great organization, provides so many resources and really has been a wonderful partner for us. To chat with folks and share our knowledge in these subject matter areas. Merit pay and getting creative with salary schedules. I mean, it's a topic that just gets the blood flowing when you think about all of the possibilities. And so we're excited to talk about that topic today. Before we set off though on merit pay, and I'm going to do a little bit of intro background, and then Adam's going to take the lion's share of our presentation today. I just want to pause and thank everybody for all the work you have done. We recently celebrated the 1-year anniversary of this COVID nightmare, I'll call it. And the education sector has been challenged in so many ways we never could have imagined, and we continue to be challenged. But the way we've seen people respond in the last year, the hard work that you have done under really just impossible circumstances, not only to deliver education, but to manage your workforces, to keep the districts running, to keep the train on the tracks, and to keep the trains running has been an effort unlike any other. And so we are truly appreciative of you as attorneys, as partners and supporters, but as community members, that you have made the sacrifices as school teams, as administrative teams, to get us to this point. And hopefully we can see the finish line, the proverbial light at the end of the tunnel. And hopefully one day this will all be a distant memory. But merit pay is a very important topic, but what we've been through the last year, just take a moment to reflect and say thank you for all you have done. With that, let's get to the topic du jour. Let's talk about merit pay. And of course, got to have the legal disclaimer slide that says that we're presenting this information for informational purposes. It's not legal advice. You all know that. If you have questions after we're done, certainly feel free to pose them. We do have the Q&A tab, and so if there are questions during the course of the presentation, you can use the Q&A tab to pose those, and Adam and I will be monitoring them, and we'll try to get those questions asked during the course of the presentation. If we get to the end and you just are bashful and don't want to ask a question in the Q&A tab, you can, of course, send us an email, and we will do our best to answer it. Q&A tab, not to be confused with the chat tab. The chat is literally for chat. Q&A is for questions. So both of those are there and available for you. Next slide, Adam. Okay, so in terms of what we're going to cover, yes, it's merit pay, but we're going to try to break this down a little bit. And these are the topics we're going to cover in the time that we have together. We are going to talk a little bit about the history of the para and kind of how we get to this point in thinking about merit pay, relevant statutes, of course. We're going to then talk about large scale merit pay and small scale merit pay, and then saving it for the end, the tantalizing topic of COVID-19 relief funds and how that might play into this equation with merit pay, amongst other things. And obviously, a very interesting few weeks here that we've seen in our legislature. I don't want to use the word posturing because that sounds political, but a little bit of posturing going on. Obviously, yesterday being the 22nd was sort of a hallmark day in the recent legislation in terms of whether or not you qualify for certain funds and whatnot. So it's been an interesting few weeks as we've tried to understand that and digest that and figure out how best to utilize those funds. And so we'll give some examples of what that might look like in the merit pay setting. Those are our topics for today. So first thing we're going to do, and for some of you on this call, this might be a little bit of review. Others maybe not so much, but we're going to get in the DeLorean, and we're going to go back 1.21 gigawatts, and we're going to go back to 1994 and talk about the background on PA 112 and when we kind of got to this point, setting up the table for talking about merit pay. We go back to May of '94 when Governor Engler signed into law PA 112, which amended the para and added some new provisions. Very specifically, the subsections 2, 3, and 4 got added to section 15 of the para, which provided in relevant parts. These are the big ones, 2, 3, and 4. A public school employer has the responsibility, authority, and right to manage and direct on behalf of the public the operations and activities of the public schools under its control. And that's one of those statements that you look at and it seems sort of basic and something that we take for granted, something we have to do and can do, but really an important legislative statement. That gets coupled with sections 3 and 4. 3, a collective bargaining between a public school employer and a bargaining representative of its employees shall not include any of the following subjects. And then the matters described in subsection 3 are prohibited subjects of bargaining between a public school employer and a bargaining representative of its employees, and for the purposes of the act, are within the sole authority of the public school employer to decide. And so that language, sole authority of the public school employer to decide, coupled with the shall not in section 3, is a big deal. And certainly there were prohibited subjects, but the expansion of this topic and the specific language sets us up for where we get to today in the current paradigms that we have from a negotiation standpoint. So PA 112 originally creates 9 prohibited subjects of bargaining, and that's great. Not without debate, not without some consternation, particularly on the part of some union groups. But that sets this new construct in terms of the dynamics between employer and employee groups and what we can talk about and not talk about. And in my education law class at OU, I like to talk about the why, right? How do we get to this point? Why are we having prohibited subjects? Why are we introducing these topics? And as we advance in time into 2011, why are we adding 7 more? I won't get us off on a tangent this morning, but think about the why. And why do we have these? I mean, yes, it's good to know that there's a para and there's prohibited subjects. What are they? And we shouldn't have them in our contracts and all that good stuff. But why do we have them? We think about the dynamics of employer and employee groups, the challenges that get presented, the gridlock that happens in negotiation. And what does creating a list of prohibited subjects do? It should clear up some gridlock, right? If there's certain things that you just can't debate about, there's just certain things that you're not authorized to negotiate about, it should maybe clear the field a little bit and make it easier to plow through the process and not have the gridlock that often characterizes employer-employee dynamics. So again, we get the original 9, we get the additional 7 in 2011. Obviously, 2011, for those of you who are in HR world, interesting time, kind of almost like we hit the reset button on employer-employee dynamics, not only adding these additional prohibited subjects, we were also doing some things from a tenure perspective and whatnot, which really changed things in an exponential way. Hard to believe that was already 10 years ago. And so we get the new 7 in 2011, teacher placement, 1248 related personnel decisions, 1249 evaluations, which has had no shortage of excitement and discussion, teacher discipline and related standards, classroom evaluations, of course, their merit-based compensation under Section 1250 of the revised school code, notification to parents under Section 1249A, and then just a year later, we get any violation of the freedom to work law being added as a prohibited subject. And so, think about this big picture then, 94, we get these initial ones, not a whole lot of activity for 15 years or so, 2011 to 2012, we get another 8 prohibited subjects added. So now the list has gotten pretty long, which depending on your perspective is a good thing or a bad thing. But merit pay obviously is included in that list. But what does it all mean? What do we mean by prohibited subject? Next slide, Adam, please.
Kevin, if I can jump in, I did just want to point out that the highlighted red, the merit-based compensation, is of course what we're talking about today, and the actual text that's in the para, that is subsection O, that deals with merit-based pay, is nowhere else in this PowerPoint. So I want to take a second to actually read it off at the risk of making everybody's eyes glaze over. So what we're talking about specifically is a provision of the para that doesn't say anything. It doesn't use the words merit pay, but what it does say is that it's a prohibited subject with respect to decisions about the development, content, standards, procedures, adoption, and implementation of the method of compensation required under Section 1250 of the revised school code, aka merit pay, decisions about how an employee performance evaluation is used to determine performance-based compensation under Section 1250, decisions concerning the performance-based compensation of an individual employee, or the impact of those decisions on an individual employee or the bargaining unit. So it's a lot of words, but it's pretty comprehensive as far as if we're talking about merit pay, it's within the discretion of the employer, and the union can't force the employer's hand. So back to you, Kevin.
Thank you, sir. And I think important to understand the restrictive nature, if you will, of the language. And I know you'll talk more about what that means in application here in a few minutes, Adam. So thank you. Generally, and again, probably a review for some of you, but what does it mean for a subject to be prohibited? We think about what our legislature has said in terms of defining this area. The matters described in subsection 3 of the para are prohibited subjects of bargaining between a public school employer and a bargaining representative of its employees, and for purposes of para are within the sole authority of the public school employer to decide, similar to the language that Adam just described. So it's very clear. It's our call to decide. That's what the legislature has said about it. But certainly we know there's been some cases, some litigation over what this looks like. And so we look at what the courts have said, and holy cow, I apologize for all the text on the slide, but important to know how the courts have looked at this. And noting that the term prohibited subjects of bargaining is not specifically defined by the legislature beyond what we just saw. The courts have construed that phrase, prohibited subjects, to be synonymous with the phrase illegal subject of collective bargaining, as it's understood within the accepted lexicon of labor relations law. So think about that: prohibited subject, illegal subject, pretty much hands off, right? Shouldn't be talking about it. We know that collective bargaining as a process requires both parties to confer in good faith, to listen to each other, of course. But what we've seen from the Michigan Court of Appeals is them saying that the legislature has simply removed the statutory requirement that public school employers listen to their employees and instructed employers not to collectively bargain with regard to these subjects. In effect, the legislature simply classified the disputed subjects as illegal subjects of collective bargaining. Well, that's from the AFL-CIO case, which obviously we all made the rounds and everybody talked about for a number of years. I suppose that's probably a glass half empty way of looking at it, but a pretty direct assessment from the Court of Appeals in terms of how they view prohibited subjects. So a few other things to think about from the cases that have flowed from these initial declarations of prohibited subjects. Either party to negotiations may refuse to discuss a prohibited subject, though you can voluntarily do so if you want. A public employer may act unilaterally with respect to any prohibited subject without bargaining to agreement or impasse. And from my perspective, that's always been the key, right? Is that we don't have to go through the process to do it. We can act unilaterally. Neither party may maintain to impasse a proposal pertaining to a prohibited subject. Good for us. Any provision in a collective bargaining agreement covering a prohibited subject is not enforceable. And I do know, and we haven't said his name yet, but our good friend, my partner, Bob Schindler, I know is on the call this morning. And one of the things that Bob does in his extensive work doing negotiations work is when he gets ready to go, it's to pull the current CBA and to flip through it and to make sure that there are no prohibited subjects in there. Everybody has worked very diligently, I think, over the years to try to remove those items if they can. But sometimes they're still in there. And I know one of the things that Bob does as an initial setting the baseline, getting the stage set for negotiations is going through and seeing if we have any prohibited subjects that are still in the contract that might need to be addressed. Either party may refuse to continue or carry over within a new contract any existing provision pertaining to a prohibited subject. And the school district is free to act unilaterally in regard to a prohibited subject of bargaining. So from a school district perspective, that all sounds pretty good, right? I mean, that seems to inure to our benefit fairly significantly in terms of those provisions and what the courts have interpreted a prohibited subject to be and the parameters of what we can and cannot do. So bargaining versus discussion, and what is the difference? And then once we cover this, we'll set Adam loose to really dive into merit pay. But it is not unlawful for a school district and union to discuss or even bargain over a prohibited subject. Again, we can voluntarily do that. I'm sure if we unleashed Tim Schindler would have some thoughts on voluntarily talking about prohibited subjects. But certainly circumstances may dictate that from time to time. That can be done voluntarily. It is a ULP for a party to insist on the bargaining of a prohibited subject. As for discussion on a prohibited subject, it is not unlawful, but again, there is no duty to do so under the para or corresponding ULP if not. And so we have a little bit of flexibility there. Whether or not we choose to exercise it is really up to us. With that, I will stop my tour down memory lane about para and the basics of sort of prohibited subjects 101. I will turn it over to Mr. Walker, who can start diving into the nuances and penumbras of merit pay. Adam, it's all yours.
Thank you, Kevin. You do memory lane quite well, and my eyes have not glazed over yet, for what it's worth. Before I jump to the next portion of this presentation, which fair warning will be some more statutory quoting, so prepare yourself for that. We'll get through it. Before I do that, I do want to point out that really what we're talking about here in the bargaining versus discussion piece. Sometimes when we talk about prohibited subjects, it's sort of like nana boo boo, right? not a very lawyerly phrase, but that's what we can say to the union. You have no say in this because it's a prohibited subject. This is a little different when we talk about merit pay because merit pay, of course, is a prohibited subject, but merit pay is never able to be completely separated from wages. And of course, the bargaining obligation applies to your wages, hours, and other terms and conditions of employment. So certainly, this is one of the cases that I think it's far more helpful to have discussions with the union. I'm not saying bargaining because, of course, there's no need for that, but certainly discussion. And when we talk about especially some of the larger scale ways to implement merit pay, really that's always going to be tied in with wages. And for that reason, you're going to want the union to discuss with you because the union may have some good ideas about how union pay can be, or how about how merit pay can be best implemented. Again, nothing that they can hold you to. but it's always good to have the discussion. I am going to jump ahead to, as I said, more reading here. So bear with me. The 1250 is what we've been talking about. It is the statute that says, except as otherwise provided, and that language is generally not relevant for our purposes here today. A school district, public school academy, or ISD shall implement and maintain a method of compensation for its teachers and school administrators that includes job performance and job accomplishments as a significant factor in determining compensation and additional compensation. I will put a pin in that for a second and we'll come back to it. The assessment of job performance shall incorporate a rigorous, transparent, and fair evaluation system that evaluates a teacher's or school administrator's performance, at least in part based upon data on student growth as measured by assessments and other objective criteria. It's a mouthful. And of course, obviously, this language is coupled with the previous section of the revised school code 1249, which is your evaluation system. So the legislature clearly had it in their mind to pair those up. I want to go back to the middle where I said determining compensation and additional compensation. So it is not simply the case that we need to put, for example, a salary schedule in the CBA, and that's sort of what's set, and then we deal with additional compensation. It is the case that merit pay can go straight into your main compensation scheme. Now, getting there, for reasons that I will dive into, may not be something that is practical. It may not be something that there is a whole lot of political will to do in your district, but it is a possibility. And it is clearly something that the legislature was sort of turning over the keys of the kingdom to school districts and ISDs to do and to handle. And it is, in theory, a robust authority. But there'll be more on that later. Moving on to another statute that impacts, or at least possibly impacts, merit pay considerations. A statute from 2017, which said 1764, which is in the State Aid Act, which says that districts and ISDs can't enter into a collective bargaining agreement that does any of the following. And sub D on that reads, you can't enter into a CBA that includes a method of compensation that does not comply with Section 1250 of the Revised School Code. Now, there's a bit of interesting history on this one from all of 4 years ago, when if you're familiar with this topic, and certainly the push and pull of unions having a say in wage decisions and wage bargaining. There's that side of that, and then there's the merit pay side of it. So if you have a statute that says you cannot include a method of compensation that doesn't comply with Section 1250 in a CBA, well, then we're starting to tangle the idea of a CBA where there are bargaining obligations and merit pay where there are no bargaining obligations. So at the time this comes out, the second half of this subdivision, subsection, does not exist. This subdivision shall not be construed to effect. That doesn't exist. What happens is everybody sort of goes, legislature, what are you doing? you are creating a difficult scenario for us where, now do we need to include merit pay inside of our CBA, which is not how it's supposed to work, because then that means that we have to bargain. And so, at the time, Governor Snyder was saying this provision is unenforceable. We're all sort of running around trying to figure out, well, gee, what do you do in the short term? Do you put something into the CBA just to kind of cover yourself? Because as you can see below, there is a penalty provision. if you violate the subsection, then you might lose 5% of your funding under under the state aid, and that's a problem, obviously. So the legislature sort of did a very quick, as quick as the legislature does, fix to that and added this subsection that says, "Whoa, never mind. We don't want this statute to conflict with the school's ability to do merit pay and keep that as a prohibited subject." So what effect this provision really has, it was kind of scary when it was implemented, because it put us in a state of confusion, and then it was rectified after that. And really, in my view, I don't think there's much to worry about. I do want to talk briefly about the MIPSARA, the retirement system provision that deals relatedly with the idea of merit pay. So it doesn't talk or it doesn't speak to Section 1250 directly, but for those of you who are not who don't hate yourselves and don't like to jump into this dead statutory text, basically what 1303A says is it sort of sets forth the idea of reportable compensation. That is, compensation that you have to make employer contributions toward for retirement purposes, and it has a list that says compensation includes salary, wages, and all the following. And one of the subsections far down says merit pay, as long as it's for the purpose of rewarding achievement of specific performance objectives. I talk about 1303A because in addition to this, there is a section that deals with, and I don't think I've included it here. No, but it deals with things that are not reportable compensation, things that certainly an employee can receive, but are not. There's not going to be an employer contribution for. There's not going to be. It's not going to be relevant for retirement purposes. Those sorts of things are bonuses, or what's really on my mind is the idea of the NSI, the normal salary increase, because what the statute says is that essentially, it doesn't use the term normal salary increase, it says normal salary schedule, but what it says is that if you have payments that are in excess of the previous year, then those aren't reportable compensation, except anything that's within what's called the NSI. And Kevin mentioned Bob Schindler. Bob Schindler and I have sort of at times in the previous year or two lived in this particular part of 1303A, because when we talk about the NSI, usually we think about administrators. Think about superintendents. We think about assistant superintendents, because what the Office for Retirement Services did, what ORS did, is they create a table for. Well, let me back up. Usually in a CBA, teachers have the EA has a salary schedule, obviously. But of course, administrators often don't, because administrators are often not in a bargaining unit. And there are some big districts in the state that have more than 3 assistant superintendents. But generally, if you have a job role that has 3 or fewer people in the unit, and that for many school districts will be superintendents, it will always be a superintendent. ORS creates the NSI, which obviously many of you are familiar with. So essentially what happens is, if you have compensation in excess of the NSI, in excess of whatever percentage ORS sets, then that doesn't get reported. Now, I mentioned this. I can hear everybody saying, "What's your point?" That we're talking not about administrators really here. My point is that when we talk about merit pay, ORS has set forth a few factors, and I'm going to jump right down to the bottom where ORS says merit pay is reportable compensation, but not if the increase in compensation exceeds the NSI. So, in theory, I suppose there could be a circumstance where if you have a merit pay scheme and you're not really connecting it to a salary schedule, in my mind, I think you would be okay. I don't think the merit pay that you implement, the merit pay scheme you implement in that hypothetical situation would create reportable compensation problems. But as I feel like I say routinely, I can't predict what judges will do. I can't predict what, basically anybody who's not me will do, and that's including the ORS. So if if ORS ever wanted to try and strike down merit pay because it's not closely connected enough to a salary schedule, I suppose that is something to keep in mind. It's not something I think would really be a huge concern, but I do want to point it out because, of course, we're not there. There's not a better place to do it than a webinar on merit pay. The other requirements for merit pay to be reportable compensation under the NIPSARA is that there has to be a specific performance objective that you have to establish before the fiscal year or before the onset of the pay period, and the employee has to take action toward achieving that specific performance objective. The objectives also have to be measurable and time bound. So you can't basically, the more it looks like a bonus and the less it looks like somebody actually earning the merit pay, that's going to affect whether it's reportable compensation. Yeah, easy, right? Well, I don't want to make it sound like it's all harder than it is, because it's not. Merit pay is a topic about which there is pretty much no case law. There hasn't been a whole lot of fighting over it because, frankly, school districts have not really. I think the legislature had it in their heads that there would be a much more robust undertaking toward implementing merit pay, and I think that has not happened for the most part. So just by way of recap, essentially, we're not obligated to bargain or discuss, but I think we should discuss in this particular case, especially when we're talking about major merit pay overhaul that might diminish wages in the CBA in some way. And I'll talk more about that, but the general idea being that you have a large pot of money, and there's only so much to go. There's only so much that can go one way or the other. The statutes, I don't think that 1764H has a huge impact. I think there is a potential, obviously the potential state aid penalty still remains, but the provision was essentially neutered. And then obviously we have the text of the para prohibited subject language in 1250 itself. Now those are all, of course, sort of located in different statutes. They all say different things, but at the end of the day, the bottom line is merit pay is in the school district, the employer control, and that's sort of the beginning point for all of this. And really, at the end of the day, it's the end point as a prohibited subject. So you're probably asking, okay, you've read me all the law. You can give me as much of a recap as you want, but I mean, we're here in a PowerPoint inside of a PowerPoint called merit pay, getting creative with salary schedules. So when are you going to get to that point? Well, sure, that's a fair point. I do love to just wax on about the law all the time, and the risk is, of course, not getting to the actual useful part for everybody else. But the fact of the
Adam,
matter
I do
is,
want to say, Adam, if I can interrupt really quickly, I do want to say that anybody who can successfully integrate a Simpsons clip into a PowerPoint gets high marks. I mean, I don't care what the rest of the content is. If you can successfully integrate a Simpsons graphic into a PowerPoint, as you have done here, it's an A+ presentation no matter what follows. So well done. Well done, my friend. That's some impressive Google searching. Well played.
Well, I appreciate the stroking of my ego as I move on through the PowerPoint to hopefully what is actually useful to take away. So everybody knows exactly what the next, well, not the next slide, but the slide after that is going to say at the top. It's going to say new tricks. So just fair warning. We've got old dogs and new tricks. When we think about merit pay, the problem is that the legislature clearly had something in mind. And the reality is many people were fine with what we had. And so the idea is, sure, 1250 affords, allows, permits, entitles school districts to robustly implement merit pay. But why would we really want to if what we had is already working? And so often what we see is we see merit pay in a couple of the following ways. Either we look at a teacher's effectiveness rating and say, okay, if they're effective or highly effective, you move up a step on the salary schedule. Cool. You might get $1, $50, $100, $500, whatever, but you might get a little bit of an extra bump in pay so that we can say that there is a merit pay system in place. But really, at the end of the day, we're just keeping what we had before. The other way to think about it is we have a pot of money, and how are we gonna divvy that up? But the problem with this is, number one, it undermines legislative directive, and quite understandably, I think there are many people who would say, yeah, but who cares? I mean, at the end of the day, the freedom to work, the right to work legislation comes in 2012, and around the same era we have the para exemptions that add 1250, as well as a number of other prohibited subjects. And it might be at the end of the day we get 5-10 years down the road, it didn't happen 5 and apparently hasn't happened 10, but maybe 15-20 years down the road we have a democratic legislature that undoes all of this, and then we've done a bunch of work for no reason. And that's understandable. Another problem, is that we limit the ability to get creative with merit pay when we have this mindset. And I do want to point out, we also have, when we have this mindset, we also have a problem with everybody getting the same boost. Again, that does undermine the legislature's idea of what would happen. But the good news is, of course, if we want to take the legislature and we agree with what they were trying to do, it gives us a lot of strengths. Before I move on, I do have to point out, this is something that certainly my colleagues have probably never noticed, but the whole I have a few provisos, a couple of quid pro quos. This image ends up in every single one of my PowerPoints in the past, and it will in the future. So Kevin loves The Simpsons. I love Aladdin, and this is the slide that it was the closest for me to add. I think I kind of shoehorned it in, but I made it. New tricks. Old dogs, new tricks. So we want to get away from the idea that merit pay needs to be based on evaluations and degrees. Because if we have this setup where you had an effective this year, you had a highly effective this year, you get a small bump. Well, that's not really using the full field of how we can use a merit pay. Now, I don't want to be misconstrued or misunderstood as saying that evaluations and degrees shouldn't play any part in a merit pay scheme. I don't think that at all, particularly if we're talking about a large scale scheme. I think that evaluations and degrees do matter. And I suppose what I'm simply saying is that the rating somebody has, the effective, highly effective, etc., it shouldn't be the be all and end all for merit pay. And I certainly think that we can take out important criteria that is involved in an evaluation and use that as a benchmark for merit pay instead of using the entire evaluation rating as a whole. So I'm going to talk a little bit about strategies, and candidly, I will certainly have an example for large scale, which is going to be the idea of an individual base wage, and then merit pay that goes beyond that. And then in the small scale, something that isn't quite as robust, but maybe tackles specific needs the district needs. Candidly, it is difficult to come up with everything under the sun, because again, when we talk about merit pay, we are talking about something that, for a large scale operation, the union is probably going to want to be involved in discussions with in some way. And more generally, at the end of the day, your individual needs in your district or your academy or ISD, it's an individual need. What I'm sitting just north of Grand Rapids, and what a school district over here needs might be different from what a school district over near Kevin in the Detroit area needs, right? So it is very much the case that that I cannot. There's no way I could set forth a list of all of the ways that you could implement merit pay. That's sort of heavy lifting that has to be done at your level. So that being said, one way that I've seen done is the idea of an individual base wage. And in this particular case, I know the union was, where I've seen it, the union was on board. It might be the case that you might deal with a union that's not on board. And so this scheme went directly in a CBA. And you might wonder how that plays along with the State Aid Act provision. I don't actually think there's a problem there. But how I've seen this done is with union signing on. And if you don't have the union signing on, not to say you couldn't do something like this, but number one, it's not going to appear directly in the CBA. And number two, you might have a little bit more of a fight. So what I've seen done is you sort of nuke the salary schedule grid, and you do something like the following. If there is a teacher with experience, say a year, then that teacher starts in the 35 to 40K range based on superintendent prerogative. If they have a bachelor's, it's a 38 to 43K if they have a master's. So if you don't have experience, you might start at 33K or something like that. And the way it works is if you're highly effective or effective in years 1 through 14, and I candidly did just pull those years out of a hat, you increase base wage by 1,500. If you're effective or highly effective in year 15 or beyond, then you pay, but you don't increase the base wage by 1,000. In other words, if somebody is making 40 grand and they get an effective or highly effective, then the next year they're making 41 and a half. And once you sort of capped out at, say, 70,000 or whatever, then you can still be eligible for the for the pay, but it doesn't go in and increase your base wage. So under the scheme, there's a few other things you can that sort of turn the levers and gears. Advanced degrees. If you are in your first year and you don't have experience and you start at, like I said, something like 32, 33 grand, and then you're effective or highly effective, then you get a bigger boost. Say a 2-3 grand payment, so that you are now aligned with people who started in the 35 to 40 range and had a year of experience. You might be thinking, look, you said you nuked the salary schedule table, but this seems pretty similar. And my response is, yeah, it's similar. But I don't mean to be glib. I certainly mean to be glib and flippant. I have broadcast the word psychology with a brain there across in a banner across the bottom of this PowerPoint slide. I'm kind of being smarmy, but the idea is, there are places where I couldn't fault you to say, well, that seems a little underwhelming as a big, large scale way to change things up. And that's true. But part of this, part of the idea of merit pay is that we do things based on we receive pay based on our accomplishments, based on our performance. And if you are trying to break people out of the mindset of, well, this is what I get, this is what I'm entitled to, I think there is something to be said for the difference in mentality that is accomplished by, okay, well, you're on an individual base wage that just applies to you, and this is how your base wage gets increased based on various factors, effective, highly effective, or more degree specializations, or even something within the evaluation that goes beyond just effective or highly effective. I think there's something to be said for that. So I would also point out that if you are not a huge fan of that, there certainly are more robust ways to implement merit pay on a large scale. It's not the case that if you're not impressed with what was above, it certainly is the case that you could roll the dice a little bit more. And certainly the union is going to be even less friendly toward that idea. But at the end of the day, the union doesn't get to make the call. So certainly there are obstacles. Number one, in the first place, you got to make sure that you, as an administrator or the school, at the school board, right? There hasn't been a whole lot of political will to do something like this, to just blow everything up, especially for if there's not some huge tangible benefit beyond the idea of a mental difference. If somebody is hung up on the idea of having number crunching that shows what a benefit is really going to be, the above doesn't work. You'd have to do something else. You could do something else, for the record. You certainly have that authority. But it is true that in my experience and the experience of my colleagues, there has not been a ton of willingness on the parts of school boards and often administrators as well to take something like this on. The other thing I've touched on is the idea of union resistance and managing that push-pull relationship between merit pay as a prohibited subject and wages, which of course is a mandatory subject. Now, I think it's worth mentioning here that I have many times now said that the union resistance, the union doesn't get to say, the union can resist all it wants, but it doesn't get to say at the end of the day how you implement your merit pay scheme. That's true, but as I said very early on in this presentation, certainly the more you are tied up with wages, the less clear the line between what you're allowed to do and what you're not allowed to do is. And so we have had if you do something, I want to play out what happens if you do something you doesn't like and they try to file an unfair labor practice. So if you end up in front of the Merc, for the last decade or so, we've had a friendly Merc. That's changing with Governor Whitmer. And at the risk of making everybody completely check out, I'm going to run on a little bit of a tangent here about a man named Sam Bagenstos. Now, Sam Bagenstos was a member of the Merc for a short time last year. He basically just went 2020, the beginning of 2020 until the fall. And you'd be forgiven for not knowing the name. You would have run across him in the context of him running for Michigan Supreme Court Justice a couple of years ago. But I know Sam Bagenstos from my time at the University of Michigan Law School as my employment law professor. And I will tell you that Sam Bagenstos, there are two things I can say about him. Number one, very goofy guy. I remember somebody in my class brought Miller High Life, and he sat there very visibly choking it down while he was giving a lecture. And he is generally what I can call a very nice guy. The second thing I can say is that as a school lawyer, as somebody that defends school districts, that counsels school districts, that is generally in my career on the side of school districts, he is somebody that I didn't want in the Supreme Court, and I did not want anywhere near the Merc, just for the sake of my clients, because my highest grade in law school was as a result of me pandering as employee friendly as I could have been, as union friendly as I could have been to Mr. Bagenstos. So he ended up, and he didn't do a whole lot while he was on Merc, but I certainly saw him issue a couple of decisions that I really had a bad feeling about, as far as where he would be on the topic of something like this. And now, of course, he was tapped by the Biden administration, but that doesn't get us out of anything, right? My point about this is Governor Whitmer replaced him. And if she put Mr. Bagenstos in the first place, who, again, very nice guy, the fact of the matter is, you are not going to get a friendly person on this topic. So we're not there yet. We still have a friendly Merc. But I would caution when considering this topic that you might not always. And the closer you get to blurring this line between merit pay and wages, the more likely you are to run afoul of the Merc. Now, at the end of the day, should that scare you off? I don't think so necessarily, because at the end of the day, if you get too close for the Merc's taste in blending your merit pay and your wages, and the merit pay scheme gets struck down, well, certainly that's not good. But at the end of the day, it's not as if the entire thing, it's not as if everything you want to do gets struck down. It's just the merit pay gets struck down, and then you're back to the drawing board on the wages issue. It's not as if the wages, it's not as if they come and say, well, you messed up on this issue, so now we're going to implement what we want. No, you go back and you just figure it out, and you probably either concede and say we're going to go back to what the scheme we had on wages, or you try to do something a little less robust with merit pay. All of which is to say there are solutions to these problems. The payoff is a good one in the scheme that I've the employee mentality payoff is a good thing in the scheme that I've laid out, and also the idea that if you start sort of busting up the idea of I hesitate to say entitlement, but the idea that this is what I get under the CBA, and move more toward an individual mindset. Okay, I accomplish X goal and I get Y amount of money. The more you start setting up that mentality, the more you can do down the line. The first step is always the hardest sometimes. The other solution, as I mentioned before, the union was on board in the example that I know of, because everybody ended up making more money under this scheme than they did previously. So it's hard for a union to really hate an idea if everybody is getting more money. But you say, Adam, look, I'm still not interested. There's not political will. We don't have the resources to just throw money at stuff, whatever. Is there anything more subtle we can do to use merit pay creatively, that rather than what you've laid out? And my response, as it was above, is, look, that's going to be dependent on your specific district. Yes, there are things you can do. No, I can't give you an exhaustive list. So essentially what you're going to have to do is assess areas of potential improvement that are, one, within the power of employees to change, and two, likely to be influenced by modest merit pay incentives. Basically, apparently I'm stuck on a mentality and psychology kick today, but essentially, obviously people are not going to be incentivized if you don't give them a big enough incentive. And obviously it has to be something that they really have control to do. And it's, I'm thinking things like perhaps test scores are probably the ones that I know are often lamented as being perhaps not really within the employee's control, because you're of course relying on other individuals, in that case students, to have good scores, which is impacted by many things beyond the teacher's control. So in my example, and I candidly had a lot of fun drawing this one up, and I can't believe Kevin let me get away with it, but Adam works under a CBA that gives him 12 sick days a year. Every year he takes every last day, many of which, there's maybe he's got a little bit of a cough, I don't know, but it's suspicious, but it's not suspicious enough to discipline. Superior Kevin laments staff shortages while Adam is around. By the way, that's poorly worded. It could be read as saying staff shortages are caused by Adam, but I like to think that hypothetical Adam here is irascible and cantankerous, but ultimately like in the endearing way, Adam's around while Kevin is talking about staff shortages and how he doesn't love it. Adam, prickly type that he is, says, "Gee willikers, Kevin, these days are mine to take under the contract, and it's not right to make us feel bad for taking what's ours." Kevin, frustrated, starts walking to his next meeting at the negotiation table with Adam's union. What can he do? Of course, if you've been paying attention, and I hope that I still have everybody, the idea that we should be doing anything at the negotiating table on a small scale issue like this, I'm not sure we should. Because if we want to do something about absenteeism, maybe it's something that you go to the negotiating table and you say, look, this is what we're planning on implementing. Here's your notice. But you probably don't want to do anything, you don't want to bargain, obviously, over your solution to this problem. What you do want to do is you want to identify the area of potential improvement, which is absenteeism and maybe entitlement to take every last day that's available. And you realize that excessive absenteeism for controllable reasons is a problem that impacts the entire system, but only the individual can solve it. So you use merit pay to encourage them to solve the problem for themselves and for you. The scheme is not extremely complicated here. It's basically, look, you get to cash in days that you don't use, and that would be a good theoretical way, at least, to tackle an absenteeism problem. If it seems like I'm jumping on very quickly, it simply is the case that I cannot, again, run through everything that is a small scale problem. But I would encourage you, if you take nothing else away from this presentation, to think about the small ways that merit pay can be used, these small problems that your district may be dealing with. And I don't mean those are insignificant problems. They may be significant, but the things that are more manageable than perhaps blowing up your entire wage system for merit pay, unless the political will is there and the means are there. I would encourage you to think about ways that you could maybe use a little bit of a carrot to entice people to resolve those small problems for you. I do want to touch very briefly on COVID-19 funding and merit pay, because I know there are certainly people who have an interest in this and have asked about this. So the obvious overall question: can I use COVID-19 relief funds for merit pay? And I hesitate to say no, period, and instead give the very lawyerly answer of it depends, but generally no, because the federal guidance on your elementary and secondary schools emergency relief funds, that is your ESSER funds, is that generally you can't use those funds for bonuses or merit pay or similar expenditures. But significantly, you can if they are related to disruptions or closures resulting from COVID-19. So in some respect, you're sort of looking backwards at what's already happened, I hope. I'm gonna knock on wood real quick here. I realize we are in the middle of the pandemic, and I will tell you that, Kevin and I were giving my last in-person presentation just a little over a year ago, and we were discussing whether March Madness was going to be canceled or not. And I can't believe I'm in a tournament with, by the way, my team Michigan's still in it. I can't believe we're sitting here still a year later giving a virtual webinar. But in any case, you can, in theory, use ESSER funds for merit pay under certain circumstances. So it would be allowable, for example, where school cafeteria workers put in extra time and effort during the pandemic to prepare and distribute meals. It would be allowable where teachers took on additional students or classes and taught both in person and virtually when other teachers in the school didn't have the same workload. It's not allowable to think, we got, and this is why I have 3 giant pots of money, right? Across the board raises coming from this massive federal relief and then trickling down to the states. You can't use that for across the board raises and payments. You can't even use it for hazard pay, in quotation marks, which is really, a bonus for working face to face before neighboring districts, because that would still be across the board pay. Essentially, what the COVID-19 funding is for is, it has to be for things that are tied to COVID. I don't mean to be glib about that or flippant about that, but you really need to link it up. And so you need to link it up individually as well. So if you're using or attempting to use COVID-19 or ESSER funds for merit pay, then you need to document, because if somebody comes asking questions, you need to be able to tell them, A, why the merit pay was warranted, and 2, why individuals, that is individual A, B, C, or I don't think you have to do it perhaps that granular. You could do it, I don't like saying classes of workers, but you could do it, for our kitchen staff needed it, for this reason, it merited it for this reason. So that's that's sort of the long and short of it. I don't have anything here on any additional funds besides the ESSER funds. Certainly, I would encourage you that if you have a specific question about other funding, to reach out to legal counsel and see if that would be eligible for merit pay. And I think with that, yep, sure did. Look
at those guys.
This picture is actually relatively recent. It feels nice. It's actually the first time I'm seeing that picture outside of the proofs. So, I feel good about it.
Well, yours looks significantly different than mine. I've got a quarantine beard going, so actually I probably look more like you, a few years older. But great job, Adam. A lot of information and a lot to try to put together to frame the issue. We've had a series of questions posed in the Q&A, and our good friend Bob Schindler has been very graciously tackling a number of them and responding. I think it's a little known fact. We actually have an agreement with M&A that we'll never present without Bob Schindler. No, I'm kidding. But we always rely on Bob heavily because he is such an expert in the area of negotiations and has been through a lot of the battles. Bob, I'm not to put you on the spot, Bob, but I thought I saw maybe you had indicated in response to one of the questions that you were going to answer it live. So I think there was maybe one that you didn't give a text response to and you were going to jump in. Am I right about that?
Yes, that is correct.
Well, take it away, my friend. Go ahead.
Oh, no, I'm sorry. Sorry, Kevin. I was no, I'm sorry. I already answered that. That was already answered. So we're good with that.
Oh, okay. All right. Well, you're better than I even thought, Bob. So well done. Well played. If you have questions that you want to put in the Q&A tab, we can answer those right now. I know M&A gave us a full 90 minutes, but we didn't necessarily think we would need it. As Adam said, if you have questions that you don't want to submit now, that you think about after the fact, our email addresses are listed there. If it's a Schindler question, we'll get it to Schindler as well to make sure he can weigh in. I think Amy from our MJ team just put something in the chat. Recording link will be provided to M&A, and that'll get emailed out later this week. And so you can certainly share the link. You can go back and watch the riveting information on merit pay. I don't see any questions popping in, so I think I'll just defer back to Kelly if Kelly wants to make any closing comments. Kelly, I think we've covered it today.
Yes, you have. Thank you. On behalf of the M&A Executive Board, I would like to thank Adam, Kevin, for sharing their insights with us today. And I also want to thank Bob Schindler, who, as Kevin mentioned, was very busy answering a lot of individual questions that were submitted. I think that worked out really well. Thank you. And I'd also like to thank Janelle, our M&A director, as well as Amy and Jeff from the Miller Johnson team, whom without their support, this webinar would not have been possible. And I want to extend a thank you to all of you who participated in our learning this morning. M&A's next professional learning opportunity will be scheduled for April 14th, where we're going to have a panel of experts from Gallagher discuss with us the 2020 pandemic, the election, and what all of that means for medical insurance and providing benefits to our employees. The Gallagher team will share with us what they see on the horizon and discuss ways to strategically position ourselves accordingly. But other than that, thank you, everybody. Really appreciate your time this morning, and I hope you have a great rest of the day.